Hi everyone, we've made it to the big finale, part 4 of suitable alternative employment, and we are talking about the reasonableness of refusing a particular role. So we've got to the stage where the employer has made an offer, it's been determined that that is suitable, but the employee has decided to refuse that offer. In summary, you're looking at the following factors: the circumstances in which the offer is made, the duration of the alternative employment, and the employee's personal situation, which is really the biggest area of dispute. So we're not looking at what the reasonable employee may have done. It's not an objective test. What we have to assess is whether the particular employee, taking into account their personal circumstances, was behaving reasonably in refusing the offer. Did they have sound and justifiable reasons for doing so at the time the decision was made? So we firstly look at the circumstances in which the offer is made. Now, this covers examples such as insufficient time to consider it, or if the employee doubts the motives behind the offer. So in one case, an employee was deemed to have been reasonable in refusing an offer, where they understood that another employee, two other employees in this case, had also been made the same offer for just one job. Secondly, the manner in which an employer has conducted its process may be relevant to reasonableness. So the case of Ward involved an employee who became disillusioned by the way the employer had conducted the redundancy process. Initially, there was a refusal to discuss the job, which eventually was offered. And eventually, Ms. Ward, in that case, refused the offer, and it was deemed to be reasonable because of the way that the process had been conducted up to that date. We also said the duration of alternative employment is important. So there may only be temporary roles that an employer can offer because of their own circumstances. And an assessment needs to be made of the length of time for which the temporary employment is offered. It's a matter of degree and fact. And I think if anything is 12 months or under, generally it's going to be reasonable for the employee to reject that role because it doesn't really provide them with much more security than being made redundant at that point. And as I said, the biggest area of dispute is the employee's own personal situation. So they are able to have regard for the life outside of work when making a decision as to whether that employment is suitable or not. So we've talked about status from a subjective perspective. It is important to consider the impact on the employee. So the perception that may be given of them in the workplace. They may, for example, have been promoted to a managerial position whilst working among their colleagues. Putting them back onto the same level from a personal perspective may be quite demeaning and embarrassing for them. Relocation is important. An employee should be prepared to at least consider that relocation. And if there is no good reason to refuse to relocate, you can be held to have unreasonably refused alternative employment. There are a couple of cases here. An architect offered an increased salary and contribution to moving expenses, was unreasonable in refusing that offer. Interestingly, that was a move from Bournemouth to Bristol, which I believe is quite a significant way away, so I'm surprised that decision was made. It's another case of Mr. McGregor demonstrated that it's important to consider the industry when deciding whether a change in location can amount to a reasonable refusal. So in this case, an employee worked in civil engineering and contracting, and it was said that a degree of mobility was always required in that industry. And Mr. McGregor was held not to have reasonably refused the job offer where there was a change in location. Interestingly, Mr. McCallum, Mr. McGregor's colleague, was deemed to have reasonably refused the offer because he had other personal circumstances. He had 5 children, some of whom suffered from ill health, and so looking outside of the specific change in location, he had other subjective reasons for turning down that employment. There may be increased time and cost of travel to a new workplace. If you are requiring an employee to spend a lot more time and cost, the refusal is likely to be reasonable. And even if the increased journey time is small, for example, subjectively it may be very important to an employee. So it's not simply the case that when we are looking at a refusal of alternative employment, we just look at the distance from an employee's home to the workplace or the additional travel time. We have to consider the story behind that. So is there something else that's preventing an employee from being able to accept that particular employment. In one particular case, an employee was only seemingly required to travel a small additional distance, but throughout her whole career she'd lived and worked in a local area. She'd walked to work, walked home at lunchtime, regularly shopped in the local shops during lunchtime, and even went swimming during a lunch break or on the way home. Even a small amount of additional travel time completely destroyed that 30-year routine that she had, and it was deemed to be a reasonable refusal of alternative employment. On a different case, an employee who suffered from claustrophobia and had a small child was held to have reasonably refused a change in workplace in central London that turned a few minutes' walk into a half an hour bus journey. Again, though, importantly, a tribunal is entitled to take into account the nature of the industry and whether travel is a prominent feature of that generally. So a van driver who worked in the construction industry was required to do an extra 12 hours of paid travel time a week. He refused the offer, and the tribunal said that working in distant sites was not unusual in the construction industry, and that was an unreasonable refusal. Finally, we just look at career choices. So an employee's personal decision to pursue a particular career path may make it reasonable for them to refuse a suitable offer. We have the example of Reedman, an employee who worked in nursing for 30 years at the time of her redundancy. She'd worked in community nursing, worked her way up to a modern matron, which meant running community and district nursing in the area. She was offered a position at a community hospital which was suitable in terms of status, skills and experience, and she said, well, my career is in community nursing, I don't want to go back into a small hospital, and that was deemed to be a reasonable refusal of alternative employment. So lots to consider in the video that we've just discussed. It's incredibly fact sensitive in terms of the suitability of a role and whether it's reasonable to have rejected. And prior to that, we have quite a few considerations in terms of the paper trail for roles that we are potentially advertising and the selection process that we go through to offer alternative employment to employees. If you do need any support on redundancy or restructure exercises, or indeed on employment law generally, or you want to sign up to our Monday morning dispatch email, which comes out on a weekly basis, not just my exciting videos, but also other topical articles of interest, please do get in touch. employmenthub@chadlaw.co.uk. Thank you.